Good morning, students. Today we are going to review the questions on Indian Partnership Act. Before we go to the questions, let us understand the basic of Partnership Act. This act extends to whole of India except the state of Jammu and Kashmir, and this act came into force with effect from 1/10/1932. And the essential characteristics of partnership is is that it is created by agreement, that is partnership deed. And such agreement may be express or implied, but agreement must be lawful. There also must be at least two partners to start a partnership firm. And in case of banking partners, the maximum number of partners is 10, and in case of other business, the maximum number of partners is restricted to 20 in number. Regarding the existence of partnership, that is true test of partnership, it is a mutual agency which is a fundamental test of partnership. Sharing of profit is not a conclusive evidence, it is only a strong evidence. Hence, the business of partnership must be carried on by all the partners or any of them acting for all, and such partner must be the agent of the firm, and hence he can bind the firm by his act. He is the principal for the acts of other partners. Hence, partnership shall be defined as it is a business carried on by all or any of them acting for all. Partnership should also be distinguished from Hindu undivided family, association, club, and co ownership before we go into the topic. Other area that needs to be read before we enter into the review of questions is types of partners. Indian Partnership Act gives the list of types of partners which are recognized. Those are actual or active partner, sleeping or dormant partner, nominal partner, partner in profits only, subpartner, partner by estoppel or holding out, minor partner. Then the position of minor partner after attaining majority is also very important. On attaining majority, it may be noted that the minor partner has the right to decide whether he shall continue in the firm or leave it. He has to decide it within 6 months, and from the date of attaining his majority, or from the date when he first comes to know that he had been admitted to the benefits of the partnership. After deciding, he has to give a public notice of his choice within the said 6 months. Any person who is competent to enter into the contract can become a partner of a firm, because partnership is created by agreement. And also, minor can be only a beneficiary of partnership, and hence he cannot be compelled to share the losses. On coming to rights of the partner, partners have various rights like right to take part in business, right to be consulted, right to access the books, right to share the profits, right to be indemnified for the loss, right to receive interest on loans or advances at 6% per annum, right to retire from the partnership, right to be consulted for admission of a new partner, right to receive remuneration if the agreement provides, right not to be expelled from the partnership, right of retiring partner to receive proportionate profits, and right to dissolve the partnership with the consent of other partners. On the other hand, there are certain compulsory duties by the partners, such as duty of good faith, that is remaining faithful to one another, duty to carry on the business to the greatest common advantage, duty to render true accounts of the firm, duty to give full information about all things affecting the business of the firm, duty to indemnify for losses caused by fraud, duty to act within authority, and duty to be liable jointly and severally. Authority of a partner can be classified into two. One is express authority, and second one is implied authority. An express authority is an authority which is given by partner by an agreement. Example: one of the partners may be authorized to operate the bank account on behalf of the firm. On the other hand, implied authority is such which is not given by an agreement but by law. It flows from the legal relations of the partners, and it is based on law of agency. It is also known as apparent or ostensible and ordinary authority. Example: the act of partner will be within the implied authority of a partner if the following conditions are satisfied. The act must be done in the ordinary course of business, and the act must be done in a usual way, which is a question of fact and circumstances, and also the act must be done in the name of the firm. Some of the examples for implied authority of a partner is to engage the employees for the partnership firm, to pledge any goods of the firm for the purpose of borrowing the money, and to borrow the money also. A certain authority which are considered outside the purview of implied authority are to open a bank account on behalf of the firm in his own name, to withdraw a suit or proceeding filed on behalf of the firm, to transfer immovable property belonging to the firm, to enter into the partnership on behalf of the firm, etc. And the final aspect of partnership, which is very important, is dissolution. Dissolution is putting a legal end to the partnership as a whole. When we study dissolution, there are two kinds of dissolution. One is dissolution of partnership, and other one is dissolution of firm. In case of dissolution of partnership, the business continues under the firm name, but in case of dissolution of firm, the business does not continue under the firm name. There is a legal end to the firm. After dissolution, the settlement of accounts has to be done. In those cases, the rights of partner, in case of settlement of accounts due to dissolution, maybe every partner is entitled to have the property of the firm applied in payment of outside debts and liabilities of the firm, and have the surplus distributed among the partners in accordance with the rights. It may also be noted that the debts of the firm shall be paid first out of the property of the firm, and if there is any surplus, it shall be distributed among the partners. Also, the liabilities of partners on dissolution are, if the public notice for dissolution is not given, the partners continue to be liable to the third parties for any act done by any of them after the dissolution. Hence, notice is very important in case of dissolution. With this introduction, let us move on to the questions as follows. Question number 1. When partnership deed does not exist, then the profit sharing ratio among the partners will be option A capital ratio, option B equal ratio, option C sacrificing ratio, and option D gaining ratio. The correct answer is option B equal ratio. When a partnership deed does not exist, then the profit sharing ratio shall be equal according to the Partnership Act 1932. Second question, a public notice is not required to be given on option A retirement of a partner, option B insolvency of a partner, option C expulsion of a partner, option D dissolution of the firm. The correct answer is option B. In other three cases, the public notice is required to absolve the partners from their own liability. But in case of insolvency, there is no such requirement, as he will not be able to take the liability. Hence, the correct answer is option B, insolvency of partner. Answer question number 3. Sharing of profits is dash evidence of existence of partnership. Option A collaborative, option B confirmative, option C conclusive, and option D non-conclusive. The correct answer is option D non-conclusive. Sharing of profits is a strong evidence and not a conclusive evidence. Agreement between them and any of the partner acting for all are also the considerations in deciding the existence of partnership. Question number 4. In case of partnership at will, notice of intention to dissolve the firm may be given option A in writing, option B verbally, option C on phone, option D by video conferencing. The correct answer is option A in writing. According to section 40, a partner has the right to dissolve a partnership operating at will. By giving notice only in writing, he will be able to obtain the consent of other partners of his intention to dissolve. Question number 5. According to Indian Partnership Act, the dissolution of firm means the dissolution of partnership between some of the partners of firm, option B majority of the partners of the firm, option C all the partners of the firm, and option D minority of the partners of the firm. The correct answer is option C all the partners of the firm. Dissolution puts a legal end to the partnership as a whole, and hence the correct answer is option C. Question number 6. A partner whose name has not been shown in the register of firms as partner of registered firm dash sue against the firm. Option A can, option B cannot, option C may sometimes, and option C may always. The correct answer is option B cannot. Only a registered firm has the right to sue. Also, during registration, partners who are mentioned in the deed only has the rights to sue against the firm, and hence the other partners cannot sue against the firm. Question number 7. Which word is permissible in the firm's name? Option A emperor, option B king, option C crown, and option D and company. The correct answer is option D and company. Section 58 subsection 3 of Indian Partnership Act says a firm name cannot contain the following words such as crown, emperor, empire, imperial, king, queen, royal, or any words expressing or implying the sanction or approval or patronage of government or the crown representatives, except where the state government signifies its consent to the use of such words as a part of firm name by order and writing. Hence, the correct answer is option D. Question number 8. A relationship between partners arise. Option A from an agreement, option B from status, option C from mutual understanding, option D from legal provisions. The correct answer is option A from an agreement. The relationship between partners arises from agreement. Only in case of HUF it arises from status, and hence option B is wrong. From mutual understanding, mutual understanding comes only out of agreement, and hence option A is once again justified. From legal provision is anyway not an option, and hence the correct answer is option A. Question number 9. Which of the following is a valid partnership? Option A, partnership between one firm and an individual. Option B, partnership between two firms. Option C, partnership between individual members of one firm and individual members of other firm. Option D, none. The correct answer is option C. Partnership is a relationship between individuals only. In other cases, it is just an association of persons. Question number 10. Every partner is an agent of the firm. Option A, the firm for the purposes of the business of the firm subject to a contract to the contrary. Option B, the other partners for the purpose of business of the firm and the other personal matters. Option C, the firm for the purposes of the business and other purposes of the firm. Option D, the firm for the purposes of the business and the firm though he is a sleeping partner of the firm. The correct answer is option A. Because partnership is for the purpose of business carried on by all or any of them acting for all, it is an extension of law of agency. Question number 11. Alterations in firm name and place of business of registered firm is covered by section dash of Indian Partnership Act 1932. Option A section 56, option A section 58, option C section 60, option D section 62. The correct answer is option C section 60. Alteration in firm name and place of business of registered firm is covered by section 60 of the Partnership Act 1932. Question number 12. Which of the following is not the right of partner, that is which he cannot claim as a matter of right? Option A, right to take part in business. Option B, right to have access to account books. Option C, right to share profits. Option D, right to receive remuneration. The correct answer is option D. The partner cannot claim remuneration as a matter of right. It is only payable if the agreement so provides. Question number 13. Compulsory distribution of firm takes place when? Option A, all or but one partner are declared as insolvent. Option B, the business of firms becomes unlawful. Option C, business of firm becomes against the public policy. And option D, any of the above. The correct answer is option D. Compulsory dissolution of firm takes place when 1. All or but one of the partners are declared insolvent. 2. Business of the firm becomes unlawful. 3. Business of the firm becomes against the public policy. And hence option D is correct. Question number 14. A partner of unregistered firm can sue for dash of the firm. Option A, goodwill. Option C, share in property. Option C, dissolution. And option D, nothing. Correct answer is dissolution. A partner of unregistered firm can sue for dissolution of the firm. Question number 15. Persons who have entered into partnership with one another are individually called? Option A, firm. Option B, partners. Option C, firm name. Option D, registered name. The correct answer is option B, partners. The persons who have entered into partnership with one another are individually called partners according to Partnership Act 1932. Every partner has right to: option A, be remunerated. Option B, consulted. Option C, receive interest on capital. Option D, to do his own business. The correct answer is option B, to be consulted. Other options are not a matter of right. Based on the partnership deed, it may vary. Hence, the correct answer is option B, to be consulted. Question number 17. A partnership deed provides that the minor were to share the profits and losses. Such documents is: option A, valid. Option B, invalid. Option C, voidable. And option D, valid to the extent of loss sharing and not profit sharing. The correct answer is option B, invalid. Minor can be only a beneficiary of partnership. He cannot be made to share the losses even though it is in writing in return deed. Question number 18. The mode of determining the existence of partnership has been laid down in section 4, section 6, section 8, section 10. The correct answer is B, section 6. The mode of determining the existence of partnership has been laid down in section 6. Question number 19. Where there is a contract that the partner shall not carry on the business other than that of the firm while he is a partner, such contract is option A valid, option B void, option C voidable at the option of partner, option D voidable at the option of firm. The correct answer is option A valid. Where there is a contract that the partner shall not carry on the business other than that of the firm while he is a partner, such contract is valid. Question number 20. Which words is permissible in the firm's name? Option A royal, option B queen, option C brothers, and option 4 emperor. The correct answer is option C brothers. According to section 58 subsection 3 of Indian Partnership Act, a firm name cannot contain any of the following words such as crown, emperor, empire, imperial, king, queen, royal, or any words expressing or implying the sanction or approval or patronage of the government or the crown representatives, except where the state government signifies its consent to use such words as part of the firm name by order in writing. Hence, the correct answer is C brothers. Question number 21. A registered firm need not intimate the alteration of its firm only with the consent need not intimate the alteration of its firm to the register of firms. Option A true, option B partly true, option C false, and option D partly false. The correct answer is option C false. A registered firm need to intimate the alteration of its firm name to the registrar of the firms to update the records of the registrar. Question number 22. A person can be admitted into an already existing firm only with the consent of all existing partners. Option A true, option B partly true, option C false, option D partly false. The correct answer is option A true. All the partners have the right to be consulted. Question number 23. In which of the following cases compulsory dissolution of partnership is not possible? Option A by notice of dissolution, option B by business becoming illegal, option C by mutual agreement, option D by transferring the business place or firm from one place to other place. Correct answer is option D. Other three options warrants compulsory dissolution. Question number 24. After dissolution of the firm, the partners have the authority to bind the firm in so far as may be necessary to wind up the affairs of the firm. Option A true, option B partly true, option C false, option D partly false. The correct answer is option A true. Winding up is necessary action to complete the dissolution procedure. Hence, the partners have to represent the firm for the purpose of winding up. Question number 25. Notice to registrar of change in constitution of dissolution of a registered firm should specify the date of change in constitution or date of dissolution. Option A true, option B partly true, option C false, and option D partly false. The correct answer is option A true. Question number 26. Identify from the following which is not one of the general duties of partners. Option A to be just and faithful to each other. Option B to render true accounts and full information of all things affecting the firm to any partner or his legal representative. Option C to carry on the business of the firm to the greatest common advantage. Option D to claim the remuneration for the services rendered by the firm. The correct answer is option A to be just and faithful to each other. The general duties of partners are to render true accounts and full information of all things affecting the firm to any partner or his legal representative, to carry on the business of the firm to the greatest common advantage, to claim the remuneration for the services rendered to the firm, and hence other three options are not in the given are not included in the act. Hence, the correct answer is A. Question number 27. As per the contract between the partners, where a partner is entitled to interest on his capital, such interest shall be payable from A only out of capital, B only out of profit, C first out of capital and then out of profits, D first out of profits and then out of capital. The correct answer is option B, only out of profits. Interest on capital is payable only in case of profits, and hence it is only out of profits. Question number 28. Which of these gives the correct definition of partnership? Option A, it is an unregistered form of private limited company. Option B, it is an oral arrangement between the parties for sharing profits of the business mutually. Option C, it is a relationship between the persons who have agreed to share the profits of the business carried on by all or any of them acting for all. Option D, it is a written agreement between the persons for sharing the profits of the business mutually. The correct answer is option C. It is a relation between the persons who have agreed to share the profits of the business carried on by all or any of them acting for all. Other options are wrong as they are not legally valid. Question number 29. Which of the following is required to be given in application for registration of firm? Names in full and permanent address of the firm's advisors. Names in full and permanent address of the firm's partners. Names in full and permanent address of firm's legal advisors. And option D, names in full and permanent address of the firm's auditors. The correct answer is option B, names in full and permanent address of the firm's partners. Other options are wrong as they are not relating as they are not relating to the data which the registrar requires. The registrar does not require the data like auditor's address or details or advisor's details, and hence it is not relevant for him to update in his records. Question number 30. A retired partner has the right to carry on the competing business with that of the firm subject to certain conditions. Option B, share profits for use of his share of the property in the firm. Option C, claim interest at 6% and share profits of the firm. Option D, A and B. The correct answer is option A and option D, A and B. Interest on capital and profits of the business are applicable only to the existing partners, and hence option Z is correct. Question number 31. To avoid liability to the third parties, a public notice of retirement should be given. Such public notice must be given by retiring partner only, all the partners of the reconstituted firm, by the retiring partner or any partner of the reconstituted firm. Or option D, any partner of the reconstituted firm. The correct answer is option C. To avoid liability to third parties, public notice of retirement should be given. Such public notice must be given by retiring partner or any partner of the reconstituted firm, because notice by one partner binds the other. Question number 32. Which of the following statement about the registration of firm is not true? Option A, it must be done at the time of its formation. Option B, it must be done at the time of it may be done at the time of formation. Option C, it may be done before filing a suit against a third party. And option D, it may be done at any time after its formation. Option A is correct. That is, it must be done at the time of its formation. According to Partnership Act, the registration of firm is not compulsory. Non-registering of the partnership firm only has certain disabilities, and hence in case of registration it may be done immediately after during the time of formation. Question number 33. Every partner has the right to: option A, take part in the business of the firm. Option B, to share exclusive profits. Option C, to use the property of the firm for personal purposes. Option D, pay taxes. The correct answer is option A, to take part in the businesses of the firm. Rights of the partners are already discussed during the introductory section, and hence the taking part in the business of the partner is one of the implied right of the partner. Sharing of profits is allowed only in case of agreement of the partnership is allowing for the same, and hence it is not a correct answer. Option C, to use the property of the firm for personal purposes is anyway not a correct answer. Paying taxes is not an option at all, and hence option A is correct. Question number 34. An agreement of partnership firm may be: option A, expressed or implied from the act done by partners. Option B, oral or in writing. Option C, both of the above. And option D, none of the above. The correct answer is option C. The partnership deed is a document which contains the terms and conditions of partnership. Such agreement may be oral or written, express or implied. Question number 35. Interest on advances by a partner to the firm may be payable. Option A, at 6% per annum. Option B, at 8% per annum. Option C, at 8.5% per annum. And option D, at any rate. The correct answer is option A, 6% per annum. A partner is entitled to the interest on advance made by him over and above his capital at the rate of 6% per annum as per Partnership Act. Question number 36. Which of the following is not correct? Option A, joined into family is governed by law relating to registration of agreements. Option B, joined into family is governed by Hindu. Option C, joined into family is governed by law of civil code procedure. Option D, both A and C. The correct answer is option D, both A and C. Joint Hindu family is governed by the laws relating registration of agreements and law of civil procedure code. Question number 37. As per the Indian Partnership Act 1932, a partner may transfer his interest in the firm. Option A, by sale. Option B, by mortgage. Option C, by charge. And option D, all of the above. The correct answer is option D, all of the above. Section 29 of Transfer of Partners Section 29 of Partnership Act says the transfer of partners' interest to outsider. A partner may transfer his interest in the firm by sale, charge, or mortgage. However, the transfer is not entitled to interfere in the conduct of the firm or require the accounts of the firm or inspect the books of the firm, and hence all the three options are correct. Question number 38. The principle involved in the case of Garner vs. Murray 1904 is option A. Deficiencies in the capital of the insolvent partners are distributed among the solvent partners in the ratio of their capital. Option B. Partners have a fiduciary relationship with each other. Option C. Partners liability is unlimited. Option D. Partners can make supernatural profits provided proper disclosures are made in this regard. The correct answer is option A. Deficiencies in the capital account of insolvent partner are distributed among the solvent partners in the ratio of their capital. Question number 39. Which of the following is not correct? Option A. Partner of the firm cannot enter into a contract with the partnership firm. Option B. A member of company can enter into a contract with the company. Option C. Partner of the firm can enter into a contract with the partnership firm. And option D. All of the above. The correct answer is option A. Partner of the firm cannot enter into a contract with partnership firm. Partnership deed itself is a contract between the partner and firm, and hence there is no need of any separate contract between partner and the partnership firm. Question number 40. Interest on capital subscribed by a partner may be provided for in the partnership deed is option A at 6% per annum provided it is payable out of profits only. Option B at 8% per annum provided it is payable only out of profits. Option C 8.5% per annum provided it is payable only out of profits. And option D at any rate provided it is payable only out of profits. The correct answer is option D. Section 13 subsection 3 right to interest on capital says in the absence of the agreement a partner is not entitled to interest on capital contributed by him. But if there is an agreement, then the interest on capital shall be payable out of profits based on the agreement. Question number 41. The essential elements of partnership is option A must coexist before a partnership can come into existence. Maybe option B may be bought within a reasonable time of a partnership coming into existence. Option C may be bought into any time either during the creation of partnership or even thereafter. Option D may not coexist before a partnership can come into existence, but they must coexist within 1 year of the partnership coming into existence. The correct answer is option A. Only on satisfying the conditions of partnership firm, that is a profit sharing agency and agreement, such partnership is deemed to exist. Question number 42. Dissolution of partnership occurs by option A death of the partner, option B insolvency of the partner, option C both of the above, and option D none of the above. The correct answer is both of the above. Dissolution of partnership occurs A by expiry of the term, by the completion of the adventure, by the retirement of the partner, by the death of the partner, and by the insolvency of the partner. Hence both death and insolvency are covered in case of dissolution. Question number 43. Compulsory dissolution includes dissolution by adjudication of all partners or all the partners but one as insolvent. Option B dissolution of business of the firm becoming unlawful. Option C all of the above, and option D none of the above. The correct answer is all of the above. Section 41. Dissolution by operation of the law or compulsory dissolution of the firm can take place when any one of the partners is adjudged as insolvent or when the business of the firm becomes unlawful. Question number 44. A person can be introduced as a partner in the firm with the consent of option A all of the partner, option B any partner, option C none of the partner, and option D some of the partner. The correct answer is all of the partners. Section 31. Introduction of a new partner is subject to section 30, which says a person may be admitted as a new partner with the consent of all the existing partner or in accordance with the contract already entered into between the partners for the admission of new partner. Hence option A is correct. Question number 45. The law of partnership is contained in the option A chapter 11 of Indian Contract Act, Indian Partnership Act 1930, Indian Partnership Act 1934, and Companies Act 1956. The correct answer is option B. It is self-explanatory. Option C, question number 46, which is not appropriate regarding option A actual partner, option B sleeping partner, option C active partner, and option C dummy partner. The correct answer is option D dummy partner. The various kinds of partners that are discussed in Partnership Act are actual, active, or ostensible partner, sleeping or dormant partner, nominal partner, sub-partner, partner in profits only, and partners by holding out. Hence, dummy partner is not contained in Indian Partnership Act 19. Question number 47, which is not true regarding the right of the minor partner? Option A, he has the right to share of the property and profits of the firm as may have been agreed upon. Option B, has the right to expel the existing partner. Option C, has the right to have access to and inspect the copy of any accounts. Option D, all of this. The correct answer is option B, has the right to expel the existing partner. A minor has the right to have access to inspect and copy the books of the firm, and hence option A and C is not correct. Option B, has the right to expel the existing partner, is correct because minor do not have such rights. And option D, all of these is anyway not an option. Question number 48. Every partner has a right to inspect the books of the firm. Option B, not no right to inspect the books of the firm. Option C, a right with the consent of other partners to inspect the books. Option D, a right to inspect the books within consent of the registrar. The correct answer is option A. Every partner has the right to inspect the books of the firm, which is already said in the implied right of the partners, and such books need not be inspected with the consent of other partners, and registrar has no duty in interfering into the right and into the affairs of the firm, and hence he need not be consulted, and hence the correct answer is option A. Question number 49, the maximum number of partners is mentioned in option A, Partnership Act, option B, General Clauses Act, option C, Companies Act, and option D, the Societies Registration Act. The correct answer is option C, Companies Act. This is already discussed in the introductory section, which where I said that the Company Acts has restricted the number of partners in a partnership firm, which says 10 in the case of banking business and 20 in the case of other business. Any number of partners exceeding the said limit is treated as illegal association as per the Companies Act, and hence option C, Companies Act, is correct. Question number 50, which of the following are not implied authority of the partner? Option A, to buy and sell the goods on behalf of the firm. Option B, to borrow the money on behalf of the firm. Option C, to enter into partnership on behalf of the firm. And option D, to engage lawyer to defend the actions against the firm. The correct answer is option C, to enter into partnership on behalf of the firm. Other three options are valid activities that the partner can represent the firm, and hence they are not correct. With this, we have finished the review sessions of the questions. In case of any queries, you can kindly email the queries to queries@greymatteracademics.com. Thank you.